All right, the last two cases on the calendar today are John Doe versus the Department of Health, and we'll begin with case number 16671. Let me get my file out real quick.
Good morning. This is Michael Smith.
Wait 1 second. Let me reset the clock.
671 first.
671 first. Yes. How much time would you like for rebuttal?
I'd like to reserve 5 minutes, please.
5 minutes? Okay. Whenever you're ready.
May it please the court, my name is Michael Smith. I represent Dr. Doe in the appeal of this order from the 18th Judicial Circuit Court. There are three issues on appeal. First is that the department's subpoena is an attempt to force Dr. Doe to testify in violation of the Fifth Amendment to the U.S. Constitution and also to the Florida Constitution.
Let's talk about your first issue on appeal, where you argue the trial court erred in applying the 2010 version of 456.057 as it relates to subpoenaing the patient's medical records.
Yes, Your Honor.
Would you agree that you win or lose on that issue based on whether we determine the statutory change is procedural versus substantive?
I don't believe I would win or lose on that issue because of the constitutional attempt to force him to testify. But it's definitely not a procedural amendment. The statute provides, section 456057, Florida statutes, provides privacy to patients to their medical records, just like the Florida Constitution does, just like federal law does. And so taking away those substantive rights is not procedural.
But the 2007 version of the statute required the department to attempt to get consent from the patient or patient's next of kin.
That's correct.
But it didn't require consent, just an attempt at consent. And so if it didn't actually require consent, then how is the patient's rights affected at all by the change?
The patients have a right to the confidentiality. The department has not complied with the statute to even attempt to get consent if you're going to go with the 2007 version, as you mentioned. So they haven't complied with the statute. So they wouldn't be entitled to the records. The patients have a right to the privacy of their records, and the department hasn't taken the steps necessary to take away that right from the patients.
But what I'm talking about is retroactivity of the, what statute do we look at? Do we look at the 2010 statute when we're dealing with a pain management clinic that they don't have to, under these circumstances, get consent from or attempt to get consent from the patient? Or do we look at the 2007 statute, which says you have to attempt to get consent from the patient? And if the change in 2010 was merely a procedural change, then and not a substantive change in the law, then there's no reason why the 2010 statute, which doesn't require them under these circumstances to get consent from the patient, would apply.
The records that the department is seeking were created prior to the amendment to the statute. The complaint that the department is investigating existed prior to the amendment to the statute. The patient's rights to the confidentiality of their records are controlled by the statute that existed when those records were created, and that was the statute that existed prior to the 2010 amendment, which is a substantive change. The legislature in 2013 amended the same statute knowing it was a substantive statute and specified in that change that the statute was to apply, the change was to apply retroactively.
Well, explain to me how the statute creates a substantive change versus a procedural one.
Because the patient's rights to the confidentiality of the records is protected by the Constitution of the state of Florida, by federal law, and by state law, and the statute only provides the Department of Health with an exception to obtain records, and it cannot be applied retroactively.
But how is the patient's rights negatively affected by the 2010 statute? The patient always has a right of confidentiality in their records.
That's correct, Your Honor.
So how did the change, which just changed the procedure that the Department of Health has to follow in order to get a subpoena for the records, how is there a substantive change in the law from 2007 to 2010?
The cases that we cited specifically talk about vested rights. The patients had a vested right to the confidentiality of their records, and it cannot be taken away.
Then how does the 2010 statute take away their vested right that they had in 2007?
Because it allows the department to have access to their records that they didn't have before.
Well, they had access to their records in 2007 as well.
Well, they could, to follow your argument, the department, I suppose, could try to comply with the 2007 version of the statute, but they're saying that they don't need to bother because this 2010 amendment provides them access to records that were created prior to the statute.
They do, so that's why in my view, as I'm looking through the case, that it comes down to, is this a procedural change or is it a substantive change? Because I would agree with you if this is a substantive change in the statute. But given that the 2007 statute, that the department did not have to get their consent, they had to seek it out, but they didn't have to get it, and if they couldn't get it, then they could subpoena. Then how there really is any real change in the rights of the patient if the patient doesn't have veto power?
The patient's rights, the patients still have a right to the confidentiality of their records. To follow your argument, if the department has not complied with the statute 2007 version and represented to the court at circuit court level that it wasn't required to, it was pursuing these records under the 2010 amendment and affirmatively stated they did not need to obtain consent and they made no effort to get consent.
Okay.
Under the 2007 version of the statute, if the patient was actually contacted to say we need a release and the patient said no, could the department then go ahead and subpoena the records anyway?
I think the patient may have a right to object to the Department of Health's pursuit of its records, but those facts are not the facts that we're here on. We're here on the fact that the department is claiming it needs to make no effort whatsoever, and it hasn't made any, and it's for records that predate the amendment to the statute that the department is trying to rely on.
But you would agree under under 2010 statute, they're not required to seek out the consent of the patient?
I would agree that they're required to attempt. They may not be required to actually obtain it, but they haven't provided anything to show they've complied with either version of the statute. The 2010 version doesn't apply to these records, and they have not complied with the earlier version of the statute.
But in 2010, they don't have to obtain, under the 2010 statute, in this case, because we're dealing, correct, with a pain clinic.
We're dealing with records that the complaint in this case came to the department in August of 2009. The amendment to the statute that the Department of Health is trying to rely on became effective in August of 2010 is when the department got the complaint. In October of 2010 is when the statute became effective. None of the records that the department really seeks, according to when they got this complaint, even existed when the statute was amended.
I got you. I understand that. The question is it okay? Is it permissible? And the correct statute isn't the correct statute, the 2010 statute. And so that's my question to you. Why isn't that the correct statute? And you're saying because you believe that the change is substantive, not procedural.
And the Lemieux case that we cited in our briefs discusses that in detail when the court was doing the HIPAA preemption analysis and talked about the substantive provisions in 456, 0574 Florida statutes. It's a substantive statute taking away the vested rights to the patients in their confidential medical information, protected by federal law and by state law and the Florida Constitution.
Okay.
So moving to our other argument is the department admitted that it already has the records it's subpoenaing. The department only seeks the subpoena to force Dr. Doe to testify against himself, also in violation of the United States Constitution, the Florida Constitution.
Well, how do you distinguish the Nash, is it the Natch case or the Nash case out of the second DCA, which says that the Fifth Amendment privilege against self-incrimination does not apply to records that are statutorily required to be kept?
I would agree with that, Your Honor. The records are, the department can obtain those records, or the department admits that it has the records. The department admitted at the hearing that the only purpose of it was to get the doctor to sign the certificate of completeness, which is testimony, and that is the Fisher case that we cited in our briefs, specifically on point. You can get a business record from someone with a subpoena, but you cannot force testimony. The whole purpose of the department subpoena is to force testimony, which they admitted at the hearing before the circuit court. And our third major argument is that the Department of Health has failed to follow its investigatory statute, which is 456-073 Florida statutes. They haven't given Dr. Doe notice of this investigation. They haven't provided him the records that they're required to provide to him. Yet they've pursued this investigation for over 6 years now without complying with their statute. That
What didn't he receive? He got a case summary, correct, at the beginning?
when a physician gets investigated by the Department of Health, the department has to give them notice of the investigation, and if they request it, the documents that initiated that investigation.
Complaint.
Well, there's also supporting documents. So whatever documents the department got to initiate the investigation, they have to give it to the physician when he requests it. That was never done.
Was it requested?
Yes, it was numerous times.
But they did provide, was it, I was looking at the record, was it a summary, a case summary?
The case summary is the description of the investigation that's created by the Department of Health investigator, but you need to see the actual document that that investigator is working from, which the physician is entitled to under the statute, in which the department refused despite numerous requests to provide,
Okay.
which is a violation of his due process rights. So just to sum up, the major issues are the Department of Health subpoena is an attempt to force testimony in violation of the federal and the Florida Constitution. The records they already have, and they're trying to, the court's order is a retroactive application of a substantive change to the statute, which is improper. It takes away the vested rights of the patients, and the department has violated Dr. Doe's due process rights in this investigation. Thank you.
Good morning, Your Honors. May it please the Court. My name is Sarah Young-Hodges, and I represent the Department of Health in this case. The Department asks that this Court affirm the order below because the trial court properly enforced this subpoena. The trial court properly applied the subpoena law that was in effect at the time the subpoena enforcement proceeding began. The appellant argues that the version of the statute that should apply is the version that was promulgated at the time the records were made. There is no merit to this argument. Federal courts have looked at a slightly similar situation where the federal subpoena law was amended in 2013 and they had subpoenas that were issued prior to the amendment date, but the enforcement proceedings began after that date, and they found that the correct law that would apply was the law that was in place at the time of the enforcement proceeding.
What about the argument from appellants that that the changes from 2007 to 2010 are substantive and that they affect the patient's right, namely their right, perhaps their right to object, their right to go to court and object to the issuance of the subpoena. And wouldn't that be a substantive change in the law from 2007 and 2010?
No, Your Honor, because as you pointed out, what isn't changing is a patient's right to confidentiality. That remains the same. What has changed is the procedure that the department can use to obtain patient records and whether or not they have to seek patient releases. Because courts should apply the law that's in effect at the time of the enforcement proceeding, the law that applies here is the 2015 version of Section 456.057-8A1. The department followed every procedure that's outlined in the 2015 version of the statute.
What about their argument that they didn't get a copy of the complaint, the initial charging document? That it does appear that the statute requires that that be given.
Yes, Your Honor. That argument is not properly brought in this proceeding. What's at issue here is whether the trial court properly enforced the subpoena, whether the department complied with its disciplinary proceedings is irrelevant to whether the trial court.
That's for a later day.
Okay.
That's what you're arguing, right? That
Correct.
it's for a later day.
Correct. What that statute.
If we assume that they did preserve that with the trial court, what is your position with regard to the, I believe in the brief it was described as the investigative file, is that correct?
Correct,
Okay.
Your Honor.
What is your position as far as what they're entitled to when the investigation is ongoing versus what they have to wait until the end of the investigation to receive?
Well, Section 456.073 sub 1, the language of the statute is, when the investigation is undertaken, the department must promptly furnish a copy of the complaint or document that resulted in the initiation of the investigation. Under this language, all the department needs to provide when the investigation is initiated is that complaint. There's nothing in the statute that says the complaint plus any further documents need to be provided.
When you say the complaint, you're talking about the complaint when the first investigation was initiated with regard to a particular patient. Because in this case we have before us, I believe the two patients that they were seeking records for is not the same patient where the original action was initiated, correct?
That's the other case, Your Honor.
Okay, all right.
But yeah, in this one, the department received a complaint from ACA, which is what was given to the appellant, which is what is required by that statute. So the department has in fact complied with the disciplinary statute at this time. So that argument is irrelevant to a subpoena enforcement proceeding, as well as the appellant has not proven we haven't provided that complaint. In fact, if you look at pages 76 to 78 of the record, in that conversation, which is at the hearing on the previously quashed subpoena, where the department had not checked the correct box for pain management clinic, if you look at that transcript, it seems that the appellant agrees that they received the complaint. They just sought additional documentation, but that statute doesn't require additional documentation. So the department has complied with that statute.
Why don't you address their Fifth Amendment argument?
The Notch case from the Second District Court of Appeal specifically states that the Fifth Amendment right does not attach to records that are required by statute to be kept. Additionally, medical records are not testimonial in nature. The appellant argues that we have every record and we just seek a certificate of completeness. The department does try to get certificates of completeness so that way when we take the case to DOE, if that's what happens, that we can certify we've looked at every one of this patient's medical records and we are confident that this physician has broken a disciplinary statute. That is why we are seeking every record so that we cross every T and dot every I and make sure that we are properly charging these licensees.
And if they don't sign the certificate of completeness?
At that point, we try to admit the records under the business records exception and go from there. What the department is trying to do is ensure that these physicians are properly charged. And that's why we want to get every record to make sure that that's the correct decision that's made.
So in getting the certificate of completeness, their position is that you're asking the appellant to then, you're forcing them to testify despite their Fifth Amendment privilege against self-incrimination. What's your position with regard to that? Basically, is that you can take a pass, you don't have to give us a certificate? And
That's correct.
Is that made perfectly aware to whoever the medical professional is that you're seeking those records from?
I can't answer that, Your Honor, because I don't seek certificates of completeness, but from what I understand, we've had numerous cases where they are not signed. And if we feel we have enough, then we move forward as is. It's just making sure that everyone's rights are protected. That is what the department is doing when it seeks every medical record about a single patient.
And receiving the records pursuant to a subpoena as opposed to whatever source from which you have them now allows you to authenticate them for purposes of the business records exception, is that correct?
Correct. And we also don't know if we have all the records. The only records we have are those that were forwarded to us from ACA. And those are just the ones that they determine there may be an issue with. So we don't know if further records would show there was no issue, at which point we wouldn't move forward. If your honors have no further questions,
No.
the department asks this court affirm the final order. Thank you.
Thank you.
You have a little over 7 minutes.
Your Honor, first I would take issue with the department's characterization of section 456073, the investigatory statute. The department says it has to give the document or the complaint or the document that initiated the investigation, and says it did that.
What about their argument that that issue really is irrelevant to the issue of the investigatory subpoena, that that's an issue for another day and the trial court should, or in the
It may
in the-
be an
in the
issue for
hearing.
another day, but they have misstated the facts. The statute says the complaint or the document that initiated the investigation. The department is trying to make you believe that the complaint that they have filled out is the complaint. No, the complaint is whatever was given to them to initiate the investigation, and that's what was not given to Dr. Doe in this case until
How does that
well after
affect
the
the
briefing.
issue? How does that affect the issuance of the subpoena and the validity of the issuance of the subpoena, which really is what we're here on?
The whole purpose of the subpoena, the department already admits that it has the records, it admitted on the record at the circuit court, and the department says even now that it has the records. The only purpose of the subpoena is to force testimony in violation of the United States Constitution and in the Florida Constitution. They're trying to force the doctor to testify against himself, which is improper. So
Well, counsel just argued that there are times when the doctors don't sign the certificate of completeness, that they just submit the records.
So they have the records, let them go forward with their hearing. Why do you want to force the physician to provide another copy of the records? That's harassment.
Well, the statute allows it. And they have, the question becomes the admissibility of those records at a subsequent hearing. And, the statute allows them to subpoena the records, and they have no way of knowing whether they have complete records until they get the subpoenaed records, right? You just have to assume that you have
Well,
all
they'll
the
have no way to
records.
know the records are complete if they get them again with another subpoena.
Well, you would
Sub-
trust that whoever, when an individual's issued a subpoena, that they comply with the subpoena and submit the records, correct? And then you can compare those with the records that you have.
That's true, but you're allowing a discovery abuse. You don't allow in any type of discovery subpoenaing over and over and over the same records just in the hope that you find some inconsistency between them. The department admits it has the records. This argument that it wants to make sure that they're complete and they get the charges correct is not what was represented to the court at the lower tribunal, where they said that they were trying to solve a hearsay exception. These records are still going to be hearsay. There's not going to be a
But there might be
testimony.
an exception to the hearsay rule if they're subpoenaed and they're, they become a business record.
They have the same exceptions available to them that they have the records right now, that they will have if they subpoena the records again. I would suggest that their whole representations about why they're seeking these records is untrue. The whole purpose is to force testimony by this physician against himself, which they admitted at the hearing.
Okay, any other arguments?